So we now come to the originality doctrine, which is probably the most important protectability requirement and doctrine for copyright law, but also, unfortunately, one that is very easily misunderstood because of the complexities involved in its application, even though on its face it seems like a simple doctrine. So let's talk about originality. Now, we've spent some time understanding the basic idea that copyright only protects expression, nothing else. Copyright does not protect ideas. Copyright does not protect facts. Copyright is limited to expression. But it isn't all expression that becomes eligible for copyright. It's only a further limited class of expression. And that's where the originality doctrine comes in. Only original expression is eligible for copyright protection. In other words, expression needs to satisfy the originality requirement for it to become eligible for copyright protection. So what does this mean? Well, it's best to begin with what originality doesn't mean. And a good way of doing this is by contrasting the originality doctrine with analogs in patent law and trademark law that might seem similar, but are actually quite different in practice in order to avoid confusion. So the first thing to note is that original in copyright law does not mean new. Or, put another way, originality is not novelty. Originality does not mean that the work of expression needs to be new in the sense of having been the first in existence. That's not what it means. The novelty requirement is unique to patent law, where one is focusing on something having never been in existence and therefore in some sense unique and new. That's not what it means in copyright law. Originality is not novelty. It's something else. The second distinction is that originality is not the same as distinctiveness. Distinctiveness is a trademark rule because in trademark you're trying to differentiate sources of identification. Something is original not necessarily because it is distinct from other things. It has a different connotation. Distinctiveness is unique to trademark law. Originality, while it hasn't been defined in the copyright statute, nevertheless over time in the interpretation of courts has come to be seen as embodying two different but important elements under U.S. copyright law. And here I want to pause to note that U.S. copyright law has developed the originality doctrine in a very different direction from the way in which other English-speaking common law countries have taken the originality doctrine. There's an important add-on that the U.S. Supreme Court grafted onto our originality doctrine that makes it distinct from the way in which other originality doctrines in other countries work, which I'll get to in a minute. But so, as I said, it has two important elements contained within it. What is the first of these? It is that the work must originate with the author. So originality derives from the word origin, and we take that seriously to mean that the work must originate with the author, must come from the author. But what exactly does that mean? And here, copyright law takes a somewhat straightforward understanding. The work is taken to originate with the author as long as it was not copied from elsewhere. So in other words, the origination element of originality is understood quite simply as a non-copying requirement, or as a requirement of independent creation, that the author or the person claiming authorship himself or herself originated and produced the work. Now, this has important ramifications if you take a step back to think about it. It means that as long as it originates in the author, it doesn't matter if there are other similar things in the world or other things that are identical to it. As long as it wasn't copied and it was independently created and originated with the author, that is enough. So here's a concrete example. Let's say I'm a photographer and I spend a lot of time arranging my camera lenses, the lighting effects, and the time of the day and the positioning of my camera to take a picture of the Statue of Liberty from a particular position in Manhattan, New York. And it comes out as a very, very nice photograph that gets a good amount of publicity. Now, let's say a few months later, another photographer, without ever hearing about or seeing the first photograph, decides to go to the exact same spot through sheer coincidence at the exact same time of day, and because of the expertise involved in photography, uses very, very, very similar camera, lighting, settings, and produces a photograph that is identical to the first photograph of the Statue of Liberty taken by the first photographer. Now, remember, the second photographer did not copy from the first photographer, knew nothing about it. It was independently created. And the photograph originated with the photographer who is claiming to be the author. Well, guess what? That satisfies, in principle, the originality requirement. The origination component, certainly, of the originality requirement, because it wasn't copied and it was independently created, even though, on the face of it, the two photographs may seem absolutely identical. The second one was not copied, but independently created. That's the first element of the modern American originality doctrine, known as the origination or the non-copying requirement. The second element of the originality doctrine in the United States was the creation of the U.S. Supreme Court in a decision known as Feist versus Rural Telephone. Before we get to the decision, let me tell you what the second element is. The second element is that it's not enough that the work originate with the author. It must also embody, what the court says, a modicum of creativity or a spark of creativity. It cannot be banal or pedestrian. It needs to have a spark of creativity. What exactly does that mean? Let's explore that by talking about the example embodied in Feist versus Rural Telephone in a minute. But for now, know that on its face, the modern American originality doctrine has two elements. The origination element, which is non-copying or independent creation, and secondly, the spark of creativity element.